first of all, thank you very much, Honourable Minister, distinguished guests, for inviting the International Labour Organization to this event, such an important event. I wanted to, I have a presentation for you. I'm unable to upload it or display it, so I hope maybe somebody on your side can display it or can enable this on my screen so that I can share this presentation. I think it will be easier to follow. While maybe that's being organized on your end, maybe just to start, and before I dig into indeed this working paper we started researching to try to identify, what are the reasons why it appears that so many workers in the culture and creative sector are not covered for social protection. But I think it's important to start with underlining that social security is a human right. So everyone, a human, have a right to social security. Of course, the reality is very, very different. We see that most people, over roughly 50% of people, do not have adequate social protection. So it is part of the mandate of this organization since the beginning, so over 100 years now, and has been reaffirmed by our constituents, who are obviously the member states, but also workers and employers, representatives, to work on extending social security to ensure universal social protection. And that is the focus of the work, in any case in the department where I work, which is the Social Protection Department. But of course, in order to do that, because the working situation or the situation of people is very, very different across sectors, across countries, the situation, it's important to identify what are the challenges that persons are experiencing in terms of accessing social protection, what are the challenges in terms of setting up a universal and adequate and sustainable social protection system, and try to provide very concrete advice. And so in this context, we had certain assumptions, which were, we knew that the culture and creative sector, workers in that sector, were really not covered. And so we wanted to try to begin to do the research to identify what might be the challenges, the specific challenges that the sector is experiencing. And then more interestingly, what can be done? What have countries done? What are some best practices to try to address these challenges? So it seems like I can now share my screen. So I'm going to go ahead and do that. And I hope, please let me know if you're able to see my presentation. So I'm going to go over this, rather quickly. The Course, there's more information. I can share more information. I think the first thing I need to start with is what is for the International Labour Organization, what is social security or social protection, right? What are we talking about? And I did, unfortunately, I had some technical difficulties, so I wasn't able to come in for all the discussions, but I heard some things at the end, and I think this is exactly it. This is providing protection, meaning, income protection, but also medical services in the case of certain situations that may arise in somebody's life, right, that they can't control, what we call contingencies. And we use as a basis the contingencies that have been set out by our landmark convention, which is Convention 102. And there are 9 specific scenarios where we want to ensure that people have protection. This is when we talk about people having access to their human right to social security, we mean having protection in these 9 scenarios. So one is ensuring medical care, so when you're ill, and then also ensuring some kind of income security when you can't go, for example, to work because you're ill. Then there's also protection in case of unemployment, something that was very important during COVID. There's protection in case of old age. So at a certain age, we're not able to be protected, to not fall into poverty. I heard protection in case of maternity, very important. Protection in case we have a disability, or the income earner of the household dies and there's no more income, so for survivors. And also protection in case of employment injury. So if we have an accident or we lose a limb at an employment, how we can protect it. And finally, protection for the maintenance of children. So everything related to childcare. So these are the things, when we're talking about extending social protection, it's very important to know that this is what we mean, right? So what do we see about this entertainment industry that might be the cause of the lack of social security? So what we see is there is an intersection between social protection coverage and the kind of coverage and adequacy of coverage with some very sector-specific factors, including, for example, something very typical in this sector, which is fluctuating employment status, irregular income, intermittent nature of work, and geographic mobility. These things will definitely impact your access to social protection and social protection systems, and then the adequacy of that social protection. And what we see is that social protection systems aren't always adapted sufficiently to these kind of contractual arrangements that are typical in this sector. When we talk about employment arrangements that are typical in this sector, we see a lot of self-employment. We see employment relationships where the workers are employed by one or more employers, open-ended contracts, fixed-term contracts. Sometimes it's full-time, often it's part-time, combination of different employments, which frankly then results in insufficient coverage in Social Security legislation. And what's important, especially from the aspect of contributory social protection, so social protection, these kind of benefits for these contingencies that I mentioned can be provided either through contributory mechanisms where the work and the employer contribute to a system and they create some sort of density over time and they have access to benefits, but also Social Security is also provided through non-contributory systems, which are basically systems that are financed through taxes. And you'll see, I'll mention this in the end, but in the end, if we want to reach universal social protection, you'll need to have a combination of both. But in the case of employees, for example, who are covered through social insurance mechanisms, because of these modalities, these employment arrangements, what we usually see is very sporadic contributions, which makes it very difficult then to access social protection. Because if you have to show that, to get an old age pension, that you've contributed for 15, 20, 30 years, but you've only contributed 1 year here and 2 years there, it's going to be very difficult to accumulate that time, right? So what are the challenges that we've seen in the sector in terms of accessing this social protection? In some cases, there are blatant legal exclusions. Apologies, I think I'm not connected. Right, okay, so now you're seeing the right slide. Apologies for that. So there are legal exclusions. What are legal exclusions? It means that the laws that are in place that grant workers in the sector access to the social protection systems are designed in such a way that end up excluding these workers. So in some cases, it will be the personal scope of the law. So for example, the Social Security law will exclude self-employed workers. So if most of the culture and creative sector workers in the country are considered to be self-employed, then they will not be covered by the Social Security system, right? So there's specific exclusions. Then there are also the way that Social Security systems are designed. So in some cases, types of workers or the employment arrangements that the sector have are only covered through voluntary means. What does that mean? It means that it's not mandatory for these workers to participate in, for example, the social insurance system. They can do so on a voluntary basis. Now, that might sound very favorable because it gives them some sort of flexibility and choice. The reality is that we know that that never results in actual social protection because people tend to think about their needs, their immediate needs, not their future needs. They may not be able to, given limitations in terms of their income, and therefore they don't contribute voluntarily. And when time comes to shove and something happens, they're not covered. So we know that it often just doesn't result in actual protection. In some countries, the issue might be in terms of the formal contract. So there won't be necessarily a formal contract between the artistic worker and their employer. And therefore, because that formal contract doesn't exist, then they're not considered to be covered under the Social Security system because sometimes oral contracts are not considered to be sufficient in terms of proof that there is an employment relationship. And what we also see, and I think this is important talking about self-employed, is that sometimes some of the workers in the sector are considered to be self-employed, but in reality, for all intents and purposes, are not actually self-employed. There is an employment relationship. However, if they are considered to be in disguised employment, then they will not effectively be covered by some social protection system. So there's some limitations in the law that can be resolved by reforming the law. Then, of course, there's also going to be some certain de facto exclusions. So they may be covered in the law, but in practice, certain limitations that are related to their employment relationship or their employment arrangements will have the impact of affecting their actual coverage in practice. So, for example, this is related to, as I already said, the diversity and the fluidity of the employment relationships. So when you're combining short-term employment with salaried employment and self-employment and other work arrangements, and then there's also interruptions in the work, in your work periods because of, for example, periods of rehearsal or of studying or of practicing. And sometimes we'll see, sometimes these periods are not considered to be work periods. So they're very important in this sector are those periods that are taken to study or to rehearse or to practice or to work on something, and however they're not taken into account in terms of working periods, and therefore they're not included in that period that's necessary to prove that you've been working and by which you've been paying, for example, social insurance contributions, which will directly impact your ability to access Social Security. Why? Well, for example, as I've already mentioned, some benefits, for example, old age benefits, you'll have to prove that you've worked for a certain number of periods of years or a certain number of years to have access to that benefit. And if that time isn't accounted for, you can't use it to prove that time. So that will definitely impact your access. And that's why we call it de facto exclusion. Also, if you have sporadic earnings, that's also going to impact your level of the benefit you're going to get, right? Because that's going to be, we're going to take into account, the social protection systems take into account your level of earnings to calculate the level of the benefits you receive. So if you're not accounting for all that income coming in, it's going to impact the level of the benefit. Of course, something that's also very typical, that we see is very typical in this sector, is the high labor mobility. And this is going to result in fragmented social protection, but also sometimes states don't have the necessary arrangements for transferring entitlements. What does this mean? Depending on how the social protection system is set up at the national level, and I think this is very important, we have to remember that the social protection of workers in the cultural and creative sector will only be as good as the national social protection system. So this is why we don't necessarily only look at how do we improve social protection for the culture and creative sector. It's how do we improve the social protection system and then make it accessible to the sector, right? Because it will only be as good as the national social protection system. And if the social protection system is fragmented, meaning that, okay, we have one scheme for employees and one scheme for the self-employed, but you can't transfer between those schemes, a worker in the sector that works sometimes as an employee, sometimes as a self-employed, won't be able to combine all those rights that they've acquired. So this will create de facto an exclusion. Also, as I've already mentioned, the irregular and diverse types of remuneration that workers receive and how to account for those. And I've already mentioned this as well, the hidden working time. So all this time practicing, rehearsing, preparing, that is very common in this sector is not necessarily accounted for under social insurance schemes, and that's going to impact access to the benefits. Like I've already given the example as regards old age pensions. So what can be done? This is what's important, right? What do we see that some countries have done to kind of address these challenges to better expand the social protection of this sector? Well, first of all, as I mentioned, it's very important that the Social Security law ensure that workers in the culture and creative sector, no matter what type of work arrangement they have, be it self-employed, part-time, full-time, salaried work or other, need to be covered by the law. So there needs to ensure that there's a review of the national social security legislation to ensure that any type of arrangement will be covered. That's the first thing. Then it's also very important, the need, and I've mentioned this, about ensuring that the actual employment relationship where it exists between the worker and the employer is not misclassified. Meaning, if there is an employment relationship where there is an employer who's employing a worker from the culture and creative sector, that the legal framework allows some kind of mechanism to clarify this employment relationship. For example, this could be a presumption of employment. So certain workers in certain types of employment, there will be a presumption that there is an employment relationship, and therefore there's an obligation both from the employer and the employee to participate in the social insurance scheme. So it's important that the law creates some sort of mechanism. Then, as we already talked about, whether, comparing whether the scheme should be mandatory or be voluntary. And as we already said, we know from experience that if you make the scheme voluntary, it's not going to result in actual coverage, and it's going to result rather in adverse selection. So there are some limitations to this, and how can the law address this? And again, as I also mentioned, it's important, of course, to have a combination of mechanisms to protect different workers in different situations. So indeed, contributory schemes will be key for ensuring adequate protection, so social insurance mechanisms. But it will be also important to combine these with non-contributory mechanisms. So, for example, social assistance, where vulnerable, low-income workers can receive an income replacement or a cash transfer in case, or essential healthcare in case they need it. For example, if a worker is already towards the end of their career, they haven't participated in the social insurance scheme because they haven't been able to, there should be a mechanism in place that's financed through taxes to ensure that at least in old age they don't fall into poverty and exclusion. So that's from the point of the legislation. What about other things that we see in terms of good practices for extending social protection to workers in the entertainment sector? Of course, something that's also important is how do we adapt the social protection system to the reality and the specific circumstances of the sector. And here what I'm talking about in particular is the eligibility criteria, so the conditions you need to meet to have access to these benefits. And what some countries have done, given these fluctuating working time and the hidden working time and these kind of things, is relaxing some of the minimum thresholds as regards income, duration, working time, for contributions to facilitate the coverage of some of these workers. So especially workers that are casual, on demand, that are temporary workers. And just to give you an example, because examples are always very, very useful and worth 1,000 words. In Argentina, for example, an artist who's accumulated at least 120 days of work, whether it's consecutive or not, will be credited with 1 year of service. So when we are talking about to access an old age pension, you need to show that you have 20 years of service or contributions. Well, in the case of Argentina, insofar as an artist can show that they've worked 120 days in a year, they will be credited 1 full year. There's a similar situation in a law in Uruguay, but this law in Uruguay also takes into account, for example, rehearsal time. So rehearsal time is counted as working time, and can be tabulated for qualifying conditions, as is the time between performances. So that's also considered to be working time. So there are legislations that have accounted for these very specific realities of the sector. It's also very important to modify the contribution collection schedule to accommodate the income pattern of workers, right? So as mentioned, if you have sporadic employment and you have to contribute every month, but you're not actually working every month, it's going to be very difficult for you to do this. So sometimes what you'll see is that in some countries, such workers will be able to contribute on an annual basis instead of a monthly basis, right? And then also allowing in this situation, for the same reasons, a deferral of contributions, in particular during economic crises or during interruptions of employment. And finally, something that's very important, and as I mentioned, because these workers in this sector, they move around different employment arrangements. Today they're self-employed, tomorrow they're employees, then they're teachers, then they're performers, and so on and so forth. There needs to be portability mechanisms that are in place. So what that means is essentially the law needs to account for, some kind of harmonization system where entitlement, if you've been contributing to this system and also contributed to this system, can be tabulated together to account for these sort of different patterns in your work arrangements. And finally, and not less important, is what can be done from the financing and the administrative point of view. So what have we seen that other countries have done to address some of these challenges from the financing and administrative point of view, and barriers that may exist that limit the actual coverage of workers in the entertainment sector? So something that's very important is, how do we simplify administrative procedures, especially for contributory schemes or for social insurance schemes, because you have to register, then you have to declare your income, there has to be some record-keeping system that shows, what your income has been, what your contributions have been, what your working time has been. And here it's really important, harnessing digital mechanisms may really facilitate these kind of processes. For some other categories of workers, they've created mobile applications to facilitate access, the registration of employees, the contribution payments. But there's also ways of harnessing digital technologies to also share more information. Sometimes the issue is just not having enough information on what your obligations are, what your rights are. It's also very important, obviously, to have a very good coordination, especially of information between different institutions. So between social security institutions, between institutions that are running single registries, obviously, very importantly, with a keen respect to the privacy of personal data. So having laws in place that allow for the right to privacy of data. And of course, there needs to be mechanisms that are in place to expand the fiscal space. So the financing that's available, the resources that are available to finance some of the access to benefits, and looking at this from a very large perspective. So indeed, the typical thing we see is contributions from employers and employees, but in this sector, there are other users of culture and art that could also be levied. And in this way, also trying to find, broadening the risk pool, the pool of resources that are there to ensure solidarity. And that's a key principle of international social security standards is solidarity, right? We have to help each other and ensure protection so that everybody can have protection. So some things that have been done by some countries, so for example, in France, funding is based by contribution from artists and their employers, but also from distributors of artistic work. So that enables the collection of contributions to be adapted to the actual sources of income, so royalties, copyright commissions. In Germany, there's shared contributions between the workers, art users, and government. So there's some subsidies from government. So there's different way of trying to find, a large pool of resources. So what are my main takeaways from this? So first of all, as I've already mentioned, it's important to have a comprehensive, coordinated approach to extending Social Security to all workers in the culture and creative sector, which combines both contributory systems, so like social insurance systems, with non-contributory systems like social assistance mechanisms. This is what will ensure reaching universal coverage. And again, I repeat, it's a human right. Everybody has a right to Social Security, so we need to do something about it. Where there are contributory schemes in place, they need to be adapted to the realities of the sector. So what I've already said, right? Self-employment, employment, part-time work, work for different employers at the same time, etc. And they also need to rely on various financing mechanisms based on this principle of solidarity. Social dialogue is very important, and that would include the participation of trade unions and guilds in the sector, as well as employer organizations. And essentially what we see is that social dialogue with the representatives of both the workers and employers of this sector ensure better coordination between the various social protection mechanism institutions. And they also ensure a better design of the policies that address the gaps in protection, because who is better to design a policy to address the gaps in social protection than those that are concerned with financing it and those that are concerned with receiving that protection, right? And the portability, as I already mentioned, the portability and transfer of the rights from one scheme to another is very important. And here I want to say within one country, so within one social protection scheme, but it also is very important for artists, especially those that are traveling between schemes in different countries, and that adds another layer of complexity. Second to last, the extension of social protection systems needs a clear determination of the nature of the employment relationship. So we see that often workers in their sectors are considered to be self-employed, but for all intents and purposes, they're not really self-employed. So the law really needs to create a mechanism to avoid this kind of disguised employment. And as I already also mentioned, the need for implementing, sound, sustainable, and equitable financing mechanisms that are based on the principles of broad risk sharing and social solidarity, as laid out in ILO Social Security standards. So with this, I'm going to conclude my presentation. I hope you were able to follow. Of course, there are other resources that are available. There's our report that's just a first report of certain best practices. We hope to build on this and extend it, and a brief. And of course, there's also our toolkit on international Social Security standards, because as I said, that is our basis. That's our framework by which we evaluate whether the social protection that workers in this sector have is adequate, and the social protection that workers in the creative and cultural sector have will only be as good as the national social protection system. So that's why we always make it as the basis of our work. So thank you very much. Of course, I'm available. I think my email is somewhere. I'm available for any questions now or later. And again, I want to thank the government and also UNESCO for extending the invitation to the ILO. Thank you.
Thank you very much, Ms. Just to make it clear to everybody, these are front runners in terms of the research here. When we're doing this desktop research at an ILO level, it's probably the most productive research that's ever been done in the creative sector. So they are leading, they're getting the leading research. We are being exposed to that. So let's just be thankful to the ILO also for being a partner to UNESCO and to the ministry in this endeavor. Another round of applause.